a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is a Melbourne solicitor taking your legal talkback calls every Tuesday morning. Good morning, David.
Good morning, Raph.
You had some homework?
I had lots of homework. Bill from Eltham, Bill from Box Hill, and Bill's question was what he wanted to do was pass a special resolution in his owners' corporation to ban short-stay accommodation.
That's right, yes.
Answer is that in 2019, the state government passed legislation to regulate short-stay accommodation, but didn't give owners' corporations the power to ban short-stay accommodation. So there's regulations, there are penalties, there's a few series of controls. But no, the legislation doesn't say that there can be a collective swell to ban them. And there's been a Victorian Supreme Court case that talked about how far an owners' corporation could go beyond the regulations. And the answer is not very far at all. So no, I'm sorry, Phil, not going to happen. And the other one was...
Hold on, didn't the state government say they'd make it so owners' corps could say no?
They haven't done it yet.
Haven't done it yet.
Yep.
Got it. Okay.
The other one was Julie from Eltham, who was ringing on behalf of her son, who was driving a courtesy bus for a pub in Narooma.
Yes.
And he got charged by the police on the basis that some of his passengers were not obeying the seatbelt laws. And it's road rule number 265 in New South Wales. And the test is, there are two tests. The first is it a public bus? The second test is how many people does it take, including the driver? If it's a public bus, and if it's a bus provided by the pub to pick up its patrons, I wouldn't call it a public bus. And it must have 12 or more seats, including the driver. So if it's a public bus, 12 seats or more, seatbelts are not the driver's problem, but not a public bus, or a public bus with less than 12 seats, it is the driver's problem. So the driver's supposed to be doing the policing. Well, I did talk to her and she said, well, he said that there were between 10 and 12 seats on the bus. So that wasn't very helpful because and the other issue is whether it's I know it's a bus, is it a public bus? I don't think that it is.
And just with our caller before the news, someone trying to steal her camellia plant, the whole plants.
Yes.
Is it against the law for me to pluck a flower from my neighbour's front garden?
It's theft.
Theft. Lemon, sprig of rosemary flower, it's theft.
Yes. We had the people who lived next door to us had a olive tree that overhung, and there's a website that tells you where you can go pluck food off other people's gardens. So one day we came out and there was not an olive on the side of the tree.
Definitely theft.
Doesn't
matter if it's overhanging the footpath.
No.
Good to know.
It's still not yours.
Sarah is calling from Fairfield with a question that is not about gardens. Sarah, what is your query for David Whiting?
Oh, good morning. Thanks for taking my call. My son passed away interstate earlier this year and he had no will, no wife or partner, no children, and really no assets apart from any super balances he had in some super accounts. I'm interested in my son's sibling having that money if it's at all possible, but it's I'm not sure how difficult it's going to be to trace his balances because he had many jobs and worked interstate for many years and we don't have detailed records.
Sarah, it's likely you can get that information from the tax office.
Right, okay.
Because if you've got his tax file number, they will know what super contributions have been made and which funds they were made to. It's part of the data that they collect. The issue from my point of view is that super funds are required to pay the legal, either a dependent, and that's not you, or the legal personal representative. So you'll need to make an application for a letters of administration of his estate in order to be able to access the super.
And would I have to make that to the Supreme Court of the state in which he passed away?
Well, as a matter of logic, yes, you would. Most of
Right.
these things are done on paper now, so I don't see you won't be. It gets a bit weird. The normal requirement is that if you live outside the state, you're required. So is your son's father still alive and part of this?
Yes, he is.
Okay, then the whole of the estate passes to the two of you, and
Right.
you can ask the court to, or if you make a joint application to run the estate, then you're the sole beneficiaries, and there won't be a requirement for a surety guarantee.
Okay.
Okay, thank you very much for your help.
Thank you.
Good luck, Sarah. Sydney is calling from Collingwood. What do you want to say, Sydney?
Hi, Raf. Morning, David. Thanks. Love your segment. I have a question about a residential tenancy issue. We recently ended a tenancy about 13 days ago, and the provider did not conduct a end of lease condition report within the 10 days as required by the Act. And then they've now gone ahead and filed a bond claim. I just wanted to know what my options are, given that they didn't even do an end of lease condition report.
Well, I don't see that the failure to do the report is fatal to their claim, but it's certainly a factor that that VCAT would take into account.
Okay. And if they wanted to do an inspection now, should I attend or should I just ignore it and let VCAT deal with it?
Well, if you do the inspection now, Sydney, you've got the ability to do a deal. If you
Right,
don't
okay.
attend the inspection, you have no ability to do anything other than, I mean, I just think, I've got a client with negotiations with a lease at the moment. They're much done face-to-face than they are by exchange of text message.
Yeah.
So,
sure.
yes,
Okay.
I would turn up, and you might concede some and not concede others. Because they'll come along and they'll tell VCAT nobody's been in the unit.
Well, they've actually had 3 inspections for reletting it before, and actually not done the inspection.
Oh, so they've booked 3 times and not turned up.
No. They've actually had open for inspection to relet the place.
Oh, okay.
Oh, right.
Well, it would have
So-
been very handy if they'd done your inspection before they let all these other people through, Sydney.
Well, indeed. That's
Indeed.
right.
So I would attend so that you can do a deal.
Good luck, Sydney. David, actually, one of the measures the state government announced last week didn't have enough detail to my mind, but they're going to have I'm pretty sure it is Rental Dispute Resolution Victoria, RDRV, as a part of VCAT.
Yes.
So effectively another...
Right next to the domestic building ones. That's it.
I don't know. Is it a good idea in principle to create another VCAT stream if they resource it properly?
I mean, I would have thought that the best way to do that would be to appoint someone to go out and have a meeting on site,
Well, I'm
as
not sure if
opposed to
they're
have a
doing that.
meeting 10 weeks later in a room.
They probably don't have the people who can do that.
No, but in a sense, isn't that the problem? If we're looking at what's the fastest way to get to an end point, have someone inspect
never
rather
put
than
you in charge, Dave.
No, absolutely, they couldn't afford me.
Send people out there.
Yes, a person.
Someone from VCAT.
So, someone from VCAT who. I was thinking the other day about the conciliations that we're looking at, because conciliation is not about trying to find the right answer.
No.
It's about trying to get people to
An
do a
acceptable
deal.
answer, yeah.
Well, if everybody hates it, it must be good. But conciliation is endeavouring to get the other person to see your point of view.
Yes.
Mediation is trying to find something in the middle, and arbitration is trying to find the truth, which might suit neither party.
Well, I'll see if I can get a number attached to RDRV, how much extra VCAT is getting. Let's move on to Justin, who is calling from Clifton Hill. Justin, what's your question?
Hi, David and Raf. Look, I was just asking David, our family, we've been involved with aged care with our parents, and we still have our mum with us at home, and just a mixture of family care and aged care package assistance. And I was wondering, we don't have a medical power of attorney for our mum, and I was recently appointed, I've been doing it anyway, the medical decision treatment maker papers were signed, and mum's GP was perfectly happy. Mum was
Had capacity. So
had capacity.
You can
Just
no
wondering
longer make a medical treatment power of attorney. They were replaced by the medical treatment decision maker.
lovely.
which is a superior document. Consider them having the same role,
Yep.
but you can then have alternates built into it. So you
Okay.
do not need the new form because you've got the new form. But if you had the old form, you wouldn't need the new form.
Gotcha.
Right? Because they're grandfathered in the legislation.
Okay.
Yep.
Terrific. Can I just ask one question? It doesn't matter whether you can help or not. If we've had many carers and it's been overwhelmingly a good experience. If we ever wanted to make a contract with any of them individually, have you done contracts like that? I mean, is there a pro forma almost in that
Terror,
sort of
Justin.
situation?
Absolute sodding terror, right?
Oh, okay.
There are two approaches. If you do it on a one-on-one basis, you might well be an employer, and you'll need to worry about work cover, and you'll need to worry about. So it'll be work cover might be an issue. The terms of employment, holiday leave, all those things.
Yep.
So yes, it is possible to have an employment contract that complies with the award. The other way to do it is if they are independent contractors and have an ABN, then they contract outside the award. But it's a really fine line as to whether you're covered or you're not. And the preference in the Fair Work is that you're covered by an award because we think it's better for you as a person. So, it's possible, but my view is it wouldn't be my first choice.
Okay. No,
Okay.
that's great. I appreciate that.
Good
Thanks,
luck, Justin. Just on the theft David was
For
talking
Camellia.
about before, this texter, oh my God, I've just realised I am a petty thief. This is a text. I have been taking overhanging fruit for literally decades. I honestly thought over the fence line was okay. Name and suburb withheld to protect my criminal identity. And I think Tony's firing this one back at you or someone. If taking a flower from my neighbour is theft, am I required to now throw all those overhanging branches carefully back instead of disposing of them myself?
Not required, Ralph.
No,
Ralph,
not
but
required.
Entitled to.
Entitled to. There you go. You're entitled to.
Your tree over my fence is your problem.
David is not making us very good neighbours in this city. I will get back to more of your questions for David Whiting in just a moment.
Hi, it's Rochelle Hunt. The Conversation Hour is a daily deep dive into issues that impact and interest or affect you. Real people, real stories. We take one issue for 1 hour every day at 11. And if you can't catch us at 11, The Conversation Hour is also a podcast. Download from the ABC Listen app.
The Conversation Hour with Rochelle Hunt. Next on ABC Radio Melbourne and the ABC Listen app.
This is ABC Radio Melbourne with Raf Epstein.
David Whiting taking your legal talk back every Tuesday morning after 10. Lily has a query in Ivanhoe. What is it, Lily?
Hi, guys. So I bought a car privately back in April, and since buying that car, it's come out that the previous owner tampered with the odometer and disconnected the check engine light, and the timing chain was stretched.
Wow.
The odometer currently reads 139,000 Ks, and it's actually done over 300,000.
Wow.
So I wanted to know if I could get compensation for that.
Yes, but I'd be going to the police.
Yeah.
Because what they've done is a criminal offence. My view is that they have lied to you and you've bought on the basis of I don't see it as an Australian consumer law issue. I see it you're entitled to compensation as a result of the commission of a crime.
Yeah. Okay.
But I would see if you can get the police interested, and then in the event that matter proceeds, you can ask the magistrates court for compensation at the time.
Okay, perfect.
Okay.
Because I've got the roadworthy that proves that when I got the car, it was 131,000, and then Hyundai has given me the service records that show that it was at 250,000 in 2017.
Wow. Okay.
Yeah.
Talk to the police.
Great. Thank you so much.
Thank you, Lily.
Good luck, Lily. That sounds dreadful. Mary is in Mornington. What's your question, Mary?
Yes, good morning. I'm a widow and redoing my will at the moment. I'm estranged from both my children, and I'm not leaving them anything in the will. So I'm just wondering what my executor's obligations are in terms of contacting my children about my death.
No obligation at all, Mary.
Okay.
So your executor has the obligation is the other way. The executor has an obligation to respond to an inquiry from your estranged child for a copy of the will, but has no obligation to seek them out and inform them of anything.
All right. So more or less, if they don't know I've died, then unless they somehow find out, then they can make an inquiry. But if they don't know and they don't find out, then there's no obligation.
No.
Okay, that's great.
That means you can die more peacefully now, does it, Mary?
It does.
Are you worried about a challenge, Mary?
Well, look, I haven't seen them in over 5 years, so I don't know. They'll only find out if they find out through a third person, which I think is unlikely.
So no death notices and an unattended cremation, is it, Mary?
Yes.
Oh, okay.
Yes, it is. All of that.
So, Mary, what you should also do is leave with your will a letter that explains why not.
Okay.
Right? Because if there is a challenge or a response, then whoever is your executor has something to work with in terms of negotiations or dealing with them.
Okay. And how is that actually settled? If they do find out and they want to contest it, does it go to court or is it some sort of negotiation? Or
It's a negotiation. It normally happens in a court environment, but it doesn't have to.
Right.
The normal process is you issue an application in the county court or the Supreme Court, depending on the size of the estate. There's exchange of position papers. Then there's a mediation. And probably 80% of them settle at mediation. And if they don't settle, then off we go to trial.
Okay, all right.
At which stage we've gobbled up a bucket load of your estate.
Yes, which, doesn't bother me. But it may bother them. I don't know.
Yep.
Did you say something about position papers or?
A letter.
Yes, if the event the proceeding is issued, then either or both of your estranged children, who would have, by the way, have separate claims, even if they may be dealt with at the same time, would be coming along and saying, my mother had a moral obligation to me which she has not discharged, and I want X, and this is why. She was a ratbag when we were growing up, right? And we're estranged. She didn't like my friends or relations, so so it just goes on and on.
It's I guess, how do they prove? I mean, I was a good mother, but I mean, how do they prove their side if they think that I wasn't?
Should get some references, Mary.
Okay. Get them now.
Absolutely, but no, that's the allegation, and so many people have no idea what happened beyond your front door.
No.
I mean, I go to funerals and you listen to eulogies about people, and you think, I didn't know that about them. I didn't know that about them, and so we don't know what Mary does behind the front door.
Well, that's right. Well, I better get
better get your references in place.
That's it.
Good luck, Mary.
Okay.
Thank you for your call.
Bye-bye. Bye.
And sorry, David, the letter you suggest she leaves, is that just to help the executor or does that have legal weight?
No, it doesn't have any legal weight, but it's to help the executor. So, if the executor in that stage can simply, because let's say you go and you get someone who's not close to you to take on the role, who has no personal knowledge of the relationship, you've got to give them something to work with. So it's here's my issue with child 1, here's my issue with child 2, the last time I saw them was in these circumstances, that kind of stuff.
So it's something to help the executor is their task.
Otherwise you've given them nothing to run with.
Frank is calling from Clayton. What do you want to ask about, Frank?
David, please, can you help me? I'm an executor, also a beneficiary of the estate, and I want to know when, with the property, it had to be, when the will had to be shared equally between the two of us left. Now,
what does your co-beneficiary say, Frank?
They're in equal with me, and they say agreement with me.
Well, Frank, as the executor, you are only entitled to acquire the property if it's provided for in the will, if each of the other beneficiaries with an interest in the property says yes, or if the court says yes. And there's a reported case in the last few years where one of the executor came along and said, we want to go by auction, but I would like to bid at the auction because that way there'll be an extra bidder and the price will be better. The court said not enough, mate. So the answer is with the consent of the beneficiaries, or if the court says yes, or the will says yes.
With the will said the places are share equally, and now do I have to pay stamp duty?
Okay, at this stage it becomes a mathematical exercise. Let's turn around and say that the estate's worth $2 million and the house is worth $1 million. All right? Then what you would do is you would do a deed of family arrangement, and you would allocate the house to your share and the cash to your sibling's share.
Yes.
And in that case, there's no stamp duty payable because you're not getting it's not disproportionate. You're getting your share just taken in a particular form. But if the house is worth $1 million and the estate's worth $1 million, then you're really paying $500,000 to acquire the property. So you'll pay stamp duty on the $500,000, not on the $1 million.
Oh, yeah. All right then.
Okay.
All right.
So sit down with the calculator.
Good luck, Frank. Thank you for your call as well. Greg is in Ballarat. Greg, what's your question?
I've just got a question, please. I have an electric motor mower, which is 10 years old, and October last year, I had to get the whole thing completely done up. It cost about $400. But the point is this, that I find now that the blade, which was in the repair, the blade underneath come off at a very high rate of speed. And I want to know, do I have to pay for the repair of this? I know it's out of warranty, I know that. But do I have to pay for the repair?
Greg, you've got to prove fault in this system. It's not a warranty claim. So you've got to come along and say the repairer did it wrongly, did it badly, was negligent, whatever. How much is the cost of repair? I'm just a little bit worried about what it's going to cost you to have the argument.
Yeah, well, it was $400 last year.
Yes, I know, but the only thing we're worried about now is the replacement of a single blade.
Well, I do have the blade, but it's got to be fitted to the machine.
Yes, but if you think that going to VCAT's going to cost you $70 or $80, what's the blade going to cost you?
Yeah, I know. I can see what you mean. Yeah.
It's practical law rather than theoretical law, Greg. It just seems to me it's going to be cheaper to fix it than it is to take someone to task.
Fair enough. Thank you very much.
Good luck, Greg. And Claire is in Surrey Hills. What did you want to ask about, Claire?
Oh, hello, guys. Yes. Mine's the previous chap that was talking about powers of attorney. I have both a medical and a financial power of attorney set up when my son was quite young, 19 or 20. So it's in joint names with my brother and my son. Now, my brother and I have had a bit of a falling out. We've not spoken for a while. Do I need to get a new power of attorney written up, and a medical one and a financial one, or can Callum, my son, just go on his own?
What you've done, Claire, is you said you've appointed them jointly. Jointly means they both need to do everything. So if that's the case, your son can't act without your brother and your brother can't act without your son. I would have thought the logical thing to do would be to do new ones.
Yeah. I
and write to him and say you've updated it and now my son is now 25. It's appropriate that he has the power on his own.
Excellent. Good.
Okay.
Thank you very much.
Good luck, Claire.
Some legal clarification. Thanks, guys. Yeah, have a wonderful day. Thank
you too. And Paul's in Inverloch. More questions about trees. What is it, Paul?
Just that onus on a neighbour in respect of their trees. Does that extend to the council? I've got a corner block, 3 21-metre high trees are 2 metres from my carport, which is connected to my house. And I've often got branches falling off and leaves. I'm trying to get the council to manage their trees better. I don't hate trees or anything like that, but I'm really concerned about...
the obligation to maintain the nature strip rests with the council. Bass Coast, isn't it?
Yes.
Yeah, so go and talk to the council. But
I have.
But now, then go and read an amazing piece of legislation called the Road Management Act, and it talks about road adjacent areas, which will be your nature strip, and the obligations on councils in relation to road adjacent areas are not great. Okay,
but it's adjacent to his house.
Well, that's yes.
Doesn't matter.
But hey, the nature strip was there first, right? So, Paul, have a look and talk to them. But there'll be hundreds of kilometres of road adjacent areas in the Shire. There's a limit to how they can police them properly. To be fair to them,
in a general residential zone, I mean, I'm happy to even pay for it, but they refuse to cut it back. That's the problem. They're refusing to remove trees that are at risk to property and to life. That's my concern.
You can talk to the Ombudsman if it's fear of life. You can go to the Ombudsman and say, this tree is going to fall and hit somebody. Make the council do something, please.
Good luck, Paul. You've got people talking this text as well. How does that work with the tree on my side of the property? I can cut it, yet I can't take the fruit. Would cutting it be theft or damage?
Oh, if you kept the branches, it would be.
Right, so you can cut it and throw it back.
The law's developed at a point where everybody's got some acres and everything that you grow is on your side of the fence in its entirety. But we know that just doesn't happen. So, yes, if I live next door to you and my tree encroaches, that's my problem. And you can come along and say, would you cut it back, please?
You could write a book on fences.
I could, but I don't think it would sell.
Oh, I think it would sell like hotcakes. David, thank you very much.
You.
No homework.
No homework.
No homework. David Whiting here every Tuesday answering your legal talkback.